In this segment, I'm going to talk about abortion in the Constitution. Last year, the Supreme Court reversed Roe v. Wade decision, which allowed abortion throughout the land. Prior to that, I had a presentation that showed why Roe v. Wade was contrary to the Constitution and what we should do about it. But now let me just use the words of the judges themselves in the Dobbs decision, which are similar to what I argued, to illustrate my points. The majority opinion for the Dobbs decision was written by Justice Alito. The document is a stinging rebuke of the Roe v. Wade decision, as well as Planned Parenthood of Southern Pennsylvania versus Casey, which revisited Roe and modified it slightly. It first gives background on the Roe case and includes this statement in that review. Even abortion supporters have found it hard to defend Roe's reasoning. One constitutional scholar wrote that he would vote for a statute very much like the one the court ended up drafting if he were a legislator. But his assessment of Roe was memorable and brutal. Roe was not constitutional law at all and gave almost no sense of an obligation to even try to be. The decision then states, "We hold that Roe and Casey must be overturned. The Constitution makes no reference to abortion, and no such right is implicitly protected by any constitutional provision, including the one on which the defenders of Roe and Casey now chiefly rely, the Due Process Clause of the 14th Amendment. That provision has been held to guarantee some rights that are not mentioned in the Constitution, but any such right must be deeply rooted in this nation's history and tradition and implicit in the concept of ordered liberty." The phrase "deeply rooted in this nation's history and tradition" is taken from another court case. The Dobbs decision states, until the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. Zero, none. No state constitutional provision had recognized such a right. The document then goes on to a lengthy discussion of how abortion had been universally regarded as a crime by all the states throughout our history up until the 1960s, when abortion rights were beginning to be asserted by a vocal minority. Even at the time of the adoption of the 14th Amendment, 3/4 of the states had laws against abortion at all stages of pregnancy. It concludes with this statement: "The inseparable conclusion is that the right to abortion is not deeply rooted in our nation's history and traditions. On the contrary, an unbroken history of prohibiting abortion on pain of criminal punishment persisted from the earliest days of the common law until 1973. Alito discusses the issue of stare decisis, the doctrine that says the court should uphold previous court opinions. Alito says stare decisis, the doctrine on which Casey's controlling opinion was based, does not compel unending adherence to Roe's abuse of judicial authority. Roe was egregiously wrong from the start. Its reasoning was exceptionally weak, and its decision had damaging consequences. In other words, it was such a bad decision we must throw out precedent." Justice Alito then illustrates that the decision of abortion should be left to the people through their elected representatives. Wielding nothing but raw judicial power, the court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves to the people. Roe and Casey represent an error that cannot be allowed to stand. Later in the text, he says, "We therefore hold that the Constitution does not confer a right to abortion. Roe and Casey must be overturned, and the authority to regulate abortion must be returned to the people and their elected representatives." The document then addresses the issue of future challenges to state abortion laws. It says, "It follows that states may regulate abortions for legitimate reasons. And when such regulations are challenged under the Constitution, courts cannot substitute their social and economic beliefs for the judgment of legislative bodies. In other words, it's a state legislative issue and the court should not overrule them. Now this sounds good and it's a win for unborn children. However, although it is good, I have a few issues with it. First, in the last statement I read, it says the states may regulate abortions for legitimate reasons. To me, that seems like a hole the courts can drive a truck through. What's to keep the lower courts from declaring that essentially nothing is a legitimate reason? Then we're right back in the same situation we were with Roe. Already, several lower courts have thrown up roadblocks to state laws limiting abortion. The battle is not over. Second, notice the attitude the court is taking. It is essentially saying the court messed up, but we, the court, are the only ones that can rectify the problem by overturning it. It's perpetuating the myth that the courts are the final say and Congress or the states can do nothing about it until the court changes its mind. I've said it many times and continue to keep stating the fact that the Constitution gave the courts no such final unchecked authority. They assumed it on their own, and Congress and the states continue to allow them to get away with it. Third, and most importantly, the document did not address the elephant in the room, the question of when life begins. Even in the language from Roe v. Wade, it acknowledges that if it is ever shown that life begins at conception, then Roe v. Wade is overturned. Roe itself states, the appellee argue that the fetus is a person within the language and meaning of the 14th Amendment. In support of this, they outline at length and in detail the well-known facts of fetal development. If this suggestion of personhood is established, the appellant case, of course, collapses, for the fetus's right to life would then be guaranteed specifically by the 14th Amendment. And it's a scientific fact that life begins at conception, regardless of what the left says. So why didn't the judges address this issue? My guess is they just didn't have the guts, because if they had, they would be compelled not only to reverse Roe, but also to declare all abortions in the United States illegal, because any abortion would violate the Due Process Clause of the 14th Amendment, which states, nor shall any state deprive any person of life, liberty, or property without due process of law. By allowing abortions, we are depriving millions of babies their lives without due process. The supposedly conservative court doesn't want to be shown as an activist court, even though they would be upholding the Constitution if they did. Instead, they want to push the issue to the states. So what is to be the practical outcome of this ruling? Will abortions in America go away, or at least be reduced significantly? Maybe abortions will be reduced a little. Of course, states have already banned abortion altogether, and more will follow. But there will also be many states like California and New York that will allow abortions at all stages of pregnancy. California has already said they will be an abortion sanctuary and encourage women to come get abortions, even paying for transportation. Several big corporations like Starbucks have said that their company will give women employees money for expenses to travel to a state that allows abortions. The left in Congress is trying to pass legislation giving our taxpayer dollars for travel expenses to women who want an abortion. Hopefully, many women will decide to keep their children or put them up for adoption because of this ruling. Time will tell. I do predict that those states that allow abortions will be judged by God with natural or economic disasters. God will not be mocked, and He will pour out His wrath on the ungodly. Of course, the party of immorality has already tried to push an abortion bill through Congress that would allow abortions throughout the land. Apparently, they didn't read the document that affirms that it's a state issue. As with the issue of slavery, Congress doesn't have the authority to approve abortion in the states that didn't want it because the Constitution does not grant any such power to the national government. The only legitimate act from Congress would be a total ban on abortion, since life begins at conception, and abortion violates the Due Process Clause of the 14th Amendment. Congress was given the power to enforce such legislation in Section 5 of that amendment. It will never happen. Like slavery, it's going to take an amendment to the Constitution to finally outlaw abortion in our land. That is what we need to push for.